pay my due time after time. I've done my sentence, but committed no crime.
Hello, everyone. This is David at 82. Let's take up Article 2 of the Constitution. Yes, this is the one that deals with the presidential powers. Article 2, Section 1. The executive power shall be vested in a president of the United States of America. He shall hold the office during the term of 4 years, and together with the vice president chosen the same term, be elected as follows. Each state shall appoint in such a manner as legislator thereof may direct a number of electors equal to the number of senators and representatives to which the state may be entitled in Congress. But no senator or representative holding office of the trust or profits of under the United States shall be appointed as an elector. So no one in office can be an elector. The electors shall meet in their respective states and vote by ballot for each person, of whom one at least shall not be an inhabitant of same state with themselves. The electors shall meet in their respective state, and vote by ballot for two persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of the persons voted for and of the number of votes for each, which list they shall sign and certify, transmitted, sealed to the seat of the government of the United States, but directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, shall open the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president. If such a number of majority of the whole number of electors appointed, and if there be more than one of who have much majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one for the president, and if person having a majority, then form the five highest of the list. The said House shall in like manner choose the president, but in choosing the president, the votes shall be taken by states, the representation for each state having one vote, a quorum for the purposes of shall consist of a member or members from which 2/3 of the states, all states, and a majority of all states shall be necessary to a choice. If in every case, after the choice of the president, person having the greatest number of votes of the electors shall be the vice president. In every case, after the choice of the president, the person having the greatest number. Oh, okay. The next person, the next highest vote gainer, shall be president. But if there should remain two or more who have equal votes, the Senate shall choose from them by ballot the vice president. The Congress may determine the time of choosing the electors and the day in which they shall give their votes, which day shall be the same throughout the United States. No person except for natural born citizens or citizens of the United States at the time of the adoption of this Constitution shall be eligible to the office of the president. Neither shall any person be eligible to the office who shall not have attained the age of 35 and been 4 years a resident within the United States. Oh, okay. I know why they wrote the second part of that. In case of removal of the president from office, or of death, resignation, or inability to discharge the powers and duties of the said office, shall devolve on the vice president, and the Congress may, by law, provide for a case of removal, death, or resignation, or inability, both of the president and vice president, declaring what office shall then act as president of such officers shall act accordingly until disability be removed or a president shall be elected. The president shall, as stated times, receive from his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected. Shall not receive within the period of an other emoluments from the United States or any other of them. Before he enter on the execution of his office, he shall take the following oath of affirmation. I do solemnly swear or affirm what I will faithfully execute the office of President of the United States and will, to the best of my abilities, preserve, protect, and defend the Constitution of the United States. Pretty point blank right there. The opening words of Article 2, Section 1 are remarkable and simple, maddeningly vague. The executive power shall be vested in the President of the United States of America, while other sections of Article 2 provide some specificity on the nature of and extent of the presidential power. For the most part of the language of the Article 2 relates to executive power is far more or less specific than that of Article 1. Opinions about the length of the president's term vary widely, with proposals ranging from a minimum of 2 years to a term of during good behavior or effectively for life. The delegates also disagree about whether the president should be eligible for re-election. The decision on a 4-year term seems to satisfy most delegates, and by avoiding mentioning anything about the president's ability for re-election, the framers left the question of how many terms the president could serve up to the voters. George Washington's decision to serve only 2 terms in office set a precedent that lasted to the presidency of Franklin Delano Roosevelt, Franklin D. Roosevelt, who won the election to the presidency 4 times, serving until his death in 1945. In 1951, Congress passed states, and the states ratified the 22nd Amendment, limiting the president to 2 terms. The next part of this Article 2, Section 1 reflects torment the convention delegates experienced as they wrestled with the question of how to give the president sufficient powers without giving him excessive power, as well as how to free him from excessive dependency on the legislator, while at the same time assuring that he did not become, in the terms, an elected monarch. While one would think, this is still all Article 1, by the way, all that. It's the second part of Article 1. While would think that the best way to do this would be to have a president elected by answerable to the people of the nation at large, the vast majority of delegates feared American people were simply too provincial. American people were too provincial to ignore the merits of possible presidential candidates across a land as vast as that of the 13 states of America, as then compromised to make a wise choice for reasons. From most conventions, the delegates inclined toward election of the president by Congress or by a more popular branch of the Congress. The House of Representatives, but this method ran a risk of voting the principle of separation of powers by making the president unduly dependent upon Congress for his election. For much of the summer in 1787, the delegates argued unproductively about various alternatives for electing the president. And finally, in the tortured language of Article 2, Section 1, they called for the creation of an electoral college, a group of independent electors selected in each of the states in such a manner as the legislator thereof may direct, who then cast their ballot for the president and the vice president. Although initially designed as a decidedly listed, where's the elitist, decidedly elitist device by which only the most knowledgeable and most distinguished men, those elected to be electors, would use their own independent judgment in casting their ballot for the president. By the election of Thomas Jefferson in 1800, the presidential electoral system had been entirely transformed by the unexpected invention of organized political parties. The newly created political party system functioned in a way that caused states of president electors to be pledged in advance. The newly created political party system functioned in a way that caused states of presidential electors to be pledged in advance to vote for a particular candidate, with the result being that American voters, whose numbers were expanded as the number of citizens eligible to vote expanded, were now casting their votes not on the basis of identity of the individual electors, but on the merits of the candidates themselves. The invention of political parties, a development occurred wholly out of the outside American constitutional system, fundamentally changing the way the Constitution operated, transforming it into a Republican but elitist political system into truly a democratic one. Americans have grumbled about the imperfection of the Electoral College system from the days when it was, first debated in the Constitutional Convention up to the present, but for the most part, it has managed to produce victors in the presidential contest whose limited legitimacy as duly elected chief executive has not been challenged. There have been exceptions. The election of John Quincy Adams, decided by the House of Representatives in 1824, the election of a minority Republican president, Abraham Lincoln, in 1860, which led to the secession of the South states, the dispute of 1876 presidential election between Samuel Tilden and Rutherford B. Hayes, in the final days of Reconstruction, and the contested election of George W. Bush in 2000, Bush v. Gore, for those who didn't know, ultimately deciding this by the Supreme Court. Each of these cases has provoked criticism of the Electoral College, but up to this point, neither Congress nor American people have moved to the obvious alternative direct popular election of the president. We've been asking, the decision to require that the president be a natural-born citizen of the United States was made in convention with little decision and probably with little thought. Indeed, 8 of the delegates of the convention had themselves been born outside the British North America. All were born in British Isles and would in any case have been eligible to serve as president because of they were citizens of the United States at the time of the adoption of the Constitution. In an age in which Americans' economy, culture, politics are increasingly shaped by recent immigrants, this particular constitutional provision seems a good candidate for amendment. This provision defines the vice president's most important duty to succeed the president in the case of his death, disability, or removal from office. The framers left the line of succession in the event of the vice president's death, disability, resignation, or removal up to Congress. The 25th Amendment, adopted in 1967, the year I was born, provided a means by which president would elect or would select, provided a means by which the president could select, with the confirmation of a majority of Congress, another vice president. Although Congress is given the responsibility of setting the president's salary, it may not increase or decrease his salary during his term of service. Provisions designated to render the presidential independent of the congressional will. It is widely believed that George Washington, when he took the first presidential oath of office in 1789, added the words, "So help me God." However, there is no written evidence to prove, beginning with Abraham Lincoln's second oath of office, many American presidents have added the phrase. Article 2, Section 2. The president shall be commander-in-chief of the Army, then the Navy of the United States, and the militia of the several states. When called into actual service of the United States, may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have the power to grant reprieves and pardons for the offenses against the United States, except for cases of impeachment. Oh, so they can't pardon for impeachment. Okay, so that's important. He shall have power by and with the advice of the Senate to make treaties, provide 2/3 of the senators present concur, and shall nominate, and by and with the advice of consent of the Senate shall appoint ambassador, other public ministers and consuls, judges of the Supreme Court, and all of his offices of the United States, whose appointment or not herein like otherwise provided for, which shall be established by law, but the Congress may by law vest the appointments of such inferior officers as they think proper in the president alone, in the court of law, or in the hands of heads of department. Okay. He shall have the power by with the advice of the Senate to be and by and with the advice of consent shall appoint. Okay. The president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. Article 2, or annotation. Article 2, Section 2 is principally concerned with outlining the powers of the president, but given the numerous powers of the modern presidency, it seems remarkably short and vague in its prescription. Certainly, the most important and controversial of these powers has devolved from the president's role as commander-in-chief of the Army and the Navy of the United States and of militias of several states. That role has given the president enormous power to make war, has sometimes come into conflict with the power of Congress to declare war, as well as the Congress power to control the financial appropriations necessary to make fighting a war possible. By the term Article 2, Section 2, the president has the primary role in entering into treaty with other nations, although it reserves to the Senate the right to approve any treaty before it assumes the force of law. The president has the power, with the advice and consent of Senate, to appoint ambassadors, ministers, justices of the Supreme Court, and other offices of the United States. In recent decades, as the Supreme Court has become more powerful and assertive branch of the federal government, members of the Senate have responded by asserting more vigorously their right to advise and consent with respect to the appointment of justice of the courts. The president's use of power to appoint all officers of the United States has increased in direct proportion to the growing power of the federal government and of the executive branches in particular. Although the founding fathers no doubt assumed that the president would appoint members of a presidential cabinet, they would perhaps have been surprised at the growth and the size and scope of the bureaucracy serving each of the cabinet departments. The president cabinet has expanded from four members in President Washington's day, the Secretary of Treasury, the Secretary of War, the Secretary of State, and the Attorney General, to 15, not including the Vice President of today. That's okay. Article 2, Section 3. He shall, from time to time, give to Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedite. He may, on extraordinary occasions, convene both houses or either of them in case of disagreement between them. With respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all officers of the United States. Annotation. President Washington and Adams addressed the Congress directly on the State of the Union, but from 1801 to 1909, the president merely sent Congress a written message beginning in 1913 and continuing to present day. The formal State of the Union address to Congress, given the beginning of each year, has become an important national ritual. Some presidents, including President Barack Obama, have convened both houses of Congress on other extraordinary occasions to address them on the subjects that they have considered important. Article 2, Section 4. The President, the Vice President, and all civil officers of the United States shall be removed from office on impeachment for convicted of treason, bribery, or other high crimes and misdemeanors. This is another one of the provisions of Article 2 that is remarkably simple and maddeningly vague. The framers of the Constitution all agreed that the president should be removed from office if he commits treason, bribery, or other crimes, but most of them believe that the President of the United States also believed the President might be removed if he were found culpable of malfeasance in office, a term used in one of the early drafts of the Constitution. On the other hand, the framers agreed that it would be improper for Congress to remove a president simply because a majority of members of Congress might disagree with him. And since malfeasance has a term with meaning that might vary in the eye of the beholder, they substituted the term misdemeanor with malfeasance. It was a term that left no one wholly satisfied, and it has caused considerable confusion in those rare cases during the presidency of Andrew Jackson, Richard Nixon, and William Jefferson Clinton, in which impeachment proceedings against the president have been initiated. Okay, and that's Article 2, Section complete. That's the layout of the presidency. Do we want, and there's section 2, if you want to read section 2 and section 3 right there. Let's continue along with Article 3. Okay, we'll do start Article 3. This is Article 3, Section 1. The judicial power of the United States shall be vested in the court and in such inferior as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their office during good behavior and shall at stated times receive their services and compensation, which shall not be diminished during their continuing in office. Annotation. Just as the framers of the Constitution considered the Congress to be the most vital branch of the new government, and therefore dealt the branches in very, very specific articles of the Constitution, so too was the placement of the judicial branch in Article 3 of the Constitution, a reflection of their views of the relative importance of that branch. The brevity and vagueness of the languages in Article 3 are similar in reflection of relative lack of concern about the judicial branch, as well as of their uncertain about its function in the new federal union. Article 3, Section 1 stipulates that there would be one Supreme Court in the nation, but in vague about the number of exact extent of the inferior courts. The provision of that all federal judges should hold their office during good behavior was intended to protect the independence of the judiciary and reinforce the separation of powers among the three branches of the new government. Article 3, Section 2, the judicial power shall extend into all cases of law and equity arising under the Constitution, the law of the United States, the treaties made or which shall be made under their authority, and consults to all cases of admiralty and maritime judiciary jurisdictions, to controversies between two or more states, between state and citizen, another state, between citizen of a different state, between citizen of the same state claiming lands under grants of different states, and between a state or the citizen thereof and foreign states and state citizens subjects. In all cases affecting ambassadors, other public ministers and consulates, and those in which state shall be party, the Supreme Court shall have original jurisdiction, and all party, Supreme Court shall have originated jurisdiction in all of the other cases before mentioned. The Supreme Court shall have appellate jurisdiction both as law and fact, with such exceptions and under the regulation of the Congress shall make. The trials in all crimes except for the case of impeachment shall be by jury, and such trials shall held in the state where the said crime shall have been committed. But when not committed within any state, trials shall be at such place or places as the Congress may by law have directed. Notation. Article 3, Section 2 defines the jurisdiction and mode of procedures of the federal court. The key phrase, to all cases in law and equity that arises from the Constitution. In other words, the jurisdiction of federal courts extending to those in areas which the United States government itself has jurisdiction. That jurisdiction, vaguely defined in 1787, has steadily increased over the more than 2 centuries in which the Constitution has been in operation. Although Article 2 or Article 3, Section 2 makes no mention of a power of judicial review, the power of Supreme Court or any other federal court to pass judgment on whether the federal, state, or state law violates the terms of the Constitution. Many, and if not most, of the delegates to the convention probably assumed that the federal courts would exercise at least some limited form of that power. In 1803, in the case of Mulberry versus Madison, the Supreme Court, in an opinion written by the Chief Justice John Marshall, enunciated a limited power over judicial review. Article 3, Section 3. Article 3, Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to enemies, giving them aid and comfort. No person shall be convicted of treason unless on testimony of two witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare that punishment of treason, but not attainder of treason, shall work corruption of blood or forfeiture except during the life of the person attainted. Congress shall have the power to declare the punishment of treason, but not attainder of treason shall work corruption of blood or forfeiture except during the life of the person shall. Oh, I understand now. Article 3, Section 3 is the only Article 3, Section 3 is the only instance in which the United States Constitution defines a specific crime of treason. Treason is defined either as a levy of war against the United States or giving aid and comfort to the enemies of the United States. The aid and comfort clause expands the definition of treason beyond physical acts of violence, e.g., to the passing of state secrets to another nation, but the Constitution also lays down specific legal procedures by which people accused of treason might be convicted of such act. The Constitution further limits the punishment of treason to the person actually committing the act, not to the family members or close associates. In 1807, in the treason trial of Aaron Burr, his role in the alleged plan to lead parts of the Louisiana Territory in a secessionist movement from the United States. Chief Justice John Marshall laid down further limitations on the definition of treason, establishing the doctrine of constructive treason, meaning that the mere planning of an act that might be considered treasonous was not sufficient grounds for conviction. In order to be convicted of treason, one actually had to commit, or at least be in the process of committing the act. Moreover, the act was simply speaking, however, stridently, in a manner with some might have to be given aid and comfort to the enemy, was given further protection by free speech guarantees in the First Amendment. So I do Article. Let's start out. Article wasn't. We can do this. Article 4, Section 1. The full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress shall be, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Annotation. The first section of Article 4 stipulates that the laws of one state may be given full faith and credit, i.e., be recognized as legitimate, in other states. This provision was an important step in creating a uniform standard of law and the rights of the nation. For example, if the state of Massachusetts recognized the marriage of the gay couple as legally valid, then other states, even if they do not have laws permitting the marriage, gay couples must recognize the marriage as valid. Section 2, Article 4, Section 2, the citizens of the state shall be entitled to all privileges and immunities of citizens in several states. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered upon to be removed to the state having jurisdiction of the crime. No person held into service or labor in one state under the laws thereof, escaping into another state, another shall, in consequence of any law or regulation therein, be discharged from such services of labor, but shall be delivered on the claim of the party to whom such services or labor may be due. Annotation. The first provision of Article 4, Section 2 is a keystone of a common standard of equal protection under the law for all American citizens. It gives to citizens of every state all the legal protections enjoyed by citizens of other states if they should be, I'm going to refine my place. If they should be residing in or traveling through one of those other states. This means, for example, that New Jersey cannot give that state one set of rights while at the same time denying citizens of New York living or working in New Jersey any of those same rights thereof. Therefore, New Jersey cannot impose higher taxes on New York workers working in New Jersey than it imposes on its residents. The other side, and the Privilege of Immunities Clause, is that which requires states to respect the laws of other states aimed at punishing persons charged with treason, felony, or other crimes by extraditing, delivering up such persons to the state having jurisdiction over the crime. The final part of Article 4, Section 2 may well have been the most reprehensive provision in the original U.S. Constitution. It requires that the government of the citizens of every state in the Union deliver up all persons held into service or labor in one state under laws thereof, escaping into another state, although nowhere mentioned those persons held to service or labor were slaves, and by requiring citizens of and states where slavery was not permitted, cooperative with citizens and governments in the slave-owning states in the return of their slaves. It made all Americans actively complicit in protecting the institution of slavery. This was rendered null and void by the passage of the 13th Amendment, which abolished slavery. Actually, was it? Article 4, Section 3, new states may be admitted by Congress into this union, but no new state shall be formed or erected within jurisdiction of any other state, nor any state be formed by the jurisdiction of two or more states or parts of states, without the consent of legislators of the states concerned, as well as of the Congress. The Congress shall have the power to dispose of and make all needful rules, regulations respecting the territories or other properties belonging to the United States, and nothing in this Constitution shall be so constructed as to prejudice any claim of the United States or any particular state. Annotation. In 1787, framers of the Constitution were mindful that in addition to the 13 original states, the United States of America consisted of a vast territory between the borders. Those states, America consisted of a vast territory between the borders of those states and the Mississippi River. Article 4, Section 3 granted Congress the authority to admit new states into the Union on equal basis with existing states. However, individual states not permitting either to divide themselves into separate states, for example, California, by the terms of the Constitution, is not permitted to divide itself into two states. Example, Northern California and Southern California. Nor is it two or more states, for example, Rhode Island and Connecticut, to combine their territory into a single state without consent of both legislators and the states involved in the Congress. Second part of Article 4, Section 3 gives to Congress considerable leeway as to what might do in a territory that have not achieved the status of a state within the federal union. Under this provision, Congress was able to grant independence to the Philippines, which was once a territory of the United States, and to the extent certain rights, for example, the right of United States citizens, although not the right to vote in the presidential election, the territory of Puerto Rico. The congressional jurisdiction also extends to the District of Columbia, which though its citizens enjoy most of the rights of citizenry of the 50 states, American states, it is not at present fully represented in Congress. Article 4, Section 4, the United States shall guarantee to every state in this union a Republican form of government, and shall protect each of them against invasions, and on application of legislator or the executive, when the legislator cannot be convened, against domestic violence. Notation: if there is a single idea expressed in Section 4, Article 4, on which all framers of the Constitution agreed, it was that the Americans should not have a Republican form of government, both in the politics of the individual states and the new federal structure that they were creating. However, there were probably as many variations in meaning of the word Republican as there were delegates, ranging from those who wanted a Democrat government directly responsible to the people, to those who wished for a more elitist government responsible to, but somewhat removed from, the people at large. The two core elements of republicanism on which all delegates could agree were that the governments should be either directly or indirectly representative in character, and that its office holders should not base their claim to the public office on hereditary privilege. The second item in this section, Article 4, was a direct response to one of the events that precipitated the calling of a constitutional convention, an armed uprising of farmers in northwestern Massachusetts, known as Shays' Rebellion. The Constitution promised states to protect against both internal and uprisings and internal invasion or internal uprisings and invasions from abroad, but at the same time assured that the states that the government will not interfere in their defenses unless asked to do so by officials from the states themselves. Thank you for staying to the end. Like, share, follow. Please remember you're all loved no matter what you do. And this is the ending of part 2 of the Constitution. Stop sharing.
We are the